Is there any other areas that you think ticketing discretion might be applied? And do you have any advice on how would the Act give better consistency to police officers? We've heard from others the concern about vulnerable populations and who would be perhaps at greater risk of not of having the criminal charges versus ticketing. Do you have any advice on how the Act could be amended to be more responsive to that concern?
Well, I think the ticketing idea is a good one in that it, as long as there are no criminal or quasi-criminal consequences, that's really what I would be concerned about, is people incurring criminal consequences from a product that, in my view, should be subject to regulatory legislation governing how we deal with it. So if we are going to be dealing with a ticketing regime where an officer is going to be having to decide something on a discretionary basis, I would like to see some guidelines in the Act or to the officers directly as to how they're supposed to come to that decision, so that there's an emphasis on the purposes of the Act, which is not necessarily to criminalize all contact with cannabis.
Would that be in the Act, or do you think maybe that would be in the regs? Or do you have a...
Possibly in the regulations. What I just would like to see is some guidelines as to how officers are to exercise their discretion, particularly in the early days of the Act until they become comfortable with moving into this new regime. Because, and obviously I don't speak for the police, but they're coming from a background of law and order where all cannabis investigations, many of them have resulted in criminal charges. So it's going to be an entire sea change of the way they look at things.
Okay. The other one that I heard a couple of you mentioned is this issue of youth, youth up to the age of 18 can only possess up to 5 grams, and then there could be criminal charges if they possess more than 5. And we heard from a previous witness that there shouldn't be differing rules between youth and adults. So adults can hold 30, but then they would be charged under the Youth Criminal Justice Act, not so. Can you help me understand that? Given that there's a different Justice Act to deal with them?
Mr. Levesque, did you want to speak to that?
I can answer, yeah. If you are under the, and correct me if I'm wrong, please, Anne. If you're charged under the criminal code, the normal regime would apply. If you're charged under the YCJA, the maximum punishment is still the same, but the principles in terms of sentencing, the objectives are completely. It's a different paradigm for the judge, and you have also some diversion measures within the YCGA, but then we have to make sure that the criterias in applying those diversion measures are at least as generous as the one in the ticketing offenses, so we don't want to expose the young persons to more as a matter of practice to more serious consequences than any adult.
So it's really the quantum. So 5 grams for a young person will expose them to criminal liability. So even, and an adult, it's 30 grams. So an adult who is arguably more morally culpable is entitled to possess more. So it sort of takes them further from the reach of the law. And admittedly, a young person would be prosecuted under the YCJA, but those are still real consequences for a young person. And it's important to remember that.
I think one or two of you mentioned edibles, and if we really are looking at reducing the opportunity for organized crime to be in this space, then edibles should be part of the legally permissible products. But we've heard, I think, from people that draft the legislation that it's very complex to bring the edibles in. There's other health safety concerns around production of it and how to properly set guidelines up, and that more time will be needed to get that regime in place. But then we've heard from other witnesses that other jurisdictions like Colorado and others have already done that. It's already, the guidelines are already there. There's sort of prototypes that could be drawn on to use that. Do you have any thoughts on that, on other jurisdictions and the applicability of, say, guidelines for edibles from Colorado to Ontario or to Canada? Does that make sense? Or?
Yeah, I think Colorado, the experience there has effectively demonstrated that the dose can be titrated. I mean, that's certainly when people think of edibles in the Canadian or North American context more broadly, they think of people eating cannabis and being subjected to highly unpredictable and sometimes very unpleasant experiences. That's not the case with edibles. And certainly my experience in canvassing the owners of the medically oriented dispensaries in the city of Vancouver suggests that for their patients, for their clients, edibles and bombs are a large part of what they want. They don't want to consume smoking or vaporizing, and they're generally, as in Colorado, working towards a much more effective titration of dose.
Thank you very much.
I have a point of order, Mr. Chair.
Yes.
I just want to do it now so I don't interrupt Dr. Carey. If I understood correctly, I heard Mr. Oliver, unless, and I apologize if I had it wrong, mention that there were only 2 ticketable items in this bill. There, in Appendix 2, it sets out the ticketable offenses, and there are 17 separate provisions of this bill.
I don't think that's a point of order, but you can debate it when you have time.
Okay, well,
I actually had.
It's okay.
I knew there was
As
2. I didn't
examples?
say there was only 2. Yeah.
okay. Thanks.
Okay.